Hello, it's Robert Ranko with the Carlson Law Firm. I am coming to you from Austin, Texas. It is currently a very rainy Monday afternoon. I hope everybody's well. Thank you for tuning in. I'm getting ready for trial. And as I've been preparing for this, as I often do, there are lots of things that cross my mind that I wish jurors could know. But even more so, which is why I'm doing this video, things that I wish the general public knew about the jury process. What you see on TV is not the jury process. You don't go in the course of 60 minutes from an incident occurring to the final verdict, appeal, the whole deal being done that quickly. I wish things move that quickly, but they don't. What are some things that we lawyers would like for the jurors to know about the jury system? And before I get to that, there is kind of a love-hate relationship between jurors, well, between lawyers and jurors. When you do us wrong, we will tell anyone who will listen something like, yeah, well, jurors are just the 12 people who weren't smart enough to get out of jury duty. That's really harsh. I don't feel that way. I don't think we should try to get out of jury duty. But like anything, if we feel like we've been jilted or we've been wronged by somebody, we have to find out a reason why they're stupid and we're right. And I would love to be on a jury. And I think it's something you should entertain. You should welcome if you have the opportunity to do it. It really is an interesting process. But there are a lot of misconceptions. So that's why I wanted to do this video. So when we think about these cases, let's say it's a car wreck case. I'm going to use that as kind of my staple, a car accident case where somebody was injured and is seeking money damages. So what do I wish a juror would know? The number one thing that I wish a juror would know who is sitting there on that case, the thing that we all wish you knew, that now you will know, is that the defendant has insurance. I promise you, if you were sitting there on a jury and somebody is in a car wreck or an injury case of some sort, and it made it all the way to trial, there is insurance. I tell you that because I think some jurors struggle with this idea of, let's say it's Mr. Jones against Mrs. Smith. So it's alleged that Mrs. Smith caused the collision. Some jurors struggle with the idea of, oh my goodness, I feel really bad because Mrs. Smith seems really nice. And if I award a big amount of money to Mr. Jones, I don't even know if she can pay it. And I feel bad. I don't want to hurt her. I don't want to take money out of her pocket, food off her table. Those are reasonable concerns. I am here to tell you, don't. That's not a reasonable concern because if she is there with a lawyer, somebody is defending her, there is insurance. We as plaintiff lawyers, we can't, it's not a good business model for us to sue people who don't have insurance and go all the way to trial. Trial is an expensive proposition. So if you are sitting there in a jury and you're worried about Mrs. Smith because she doesn't look like she has much money, she's elderly, she doesn't work, whatever, I am here to tell you it's okay. She has a lawyer that's been paid for and appointed by the insurance company. Whatever money is awarded is going to be paid by the insurance company, and don't worry about it. Now, we're not allowed to tell you that at trial, in part because I think they don't want jurors like penalizing. If you knew that Allstate or State Farm or Geico was defending and indemnifying for the case, indemnifying just means paying for the damages. If you knew that, you might be inclined, especially if you didn't like State Farm or Allstate or whatever company, you might say, yeah, I'm going to stick it to State Farm. They stuck it to me and I'm going to get them back. I'm also here to tell you, don't do that. The instructions that the jurors get is to assess the damages, regardless of who's paying, regardless of one's ability to pay. Figure out what it's worth. If there was medical expenses, if there was time off from work, if there was mental anguish, pain and suffering, all these non-economic stuff, you'll be instructed that those all count for something and you get to decide how much it's worth. But we don't want to worry about Mrs. Smith, that she might not be able to pay. But we also don't want to, I am not telling you, and it would be wrong, just because Allstate is a multi-billion-dollar corporation doesn't mean you should just go sticking it to them. That's not fair either, and that's contrary to the instructions that you would get. So there is insurance. So don't worry about that. Number two, let's say in our hypothetical car wreck case that it's a relatively minor case and the jury awards $10,000. Some of that's for medical expenses, some of that's for mental anguish, pain, and suffering, maybe some of that's for lost wages, but the final amount is $10,000. Does that amount go to the plaintiff? No. Out of that $10,000, everything has to come. Attorney's fees, attorney's expenses, medical expenses, that all needs to be deducted before the plaintiff gets any money. You know, sometimes people think they awarded $10,000. Oh my goodness, I can't believe the plaintiff was so lucky to get all that money. Well, chances are, if it was a $10,000 verdict, they didn't get all of that. They did have to pay things out of that. So I'm not, and again, you need to follow the instructions that the jurors get. Just be aware that it's not a windfall if they have to pay all those things out of it. So that's all I have for today. Thank you so much for watching, but just as a general point of information, I hope this is helpful. And now I can assume that people are a little better educated on the civil justice process. Thank you for watching.